counseling. Are we good?
Yep, we're good.
All right, we're going to get started here on our Wednesday workshop at the Bridge. I'm Kyle Moore, local attorney here. I practice in Shreveport. Native of Natchitoches, Louisiana, right down the road. And I practice at the law firm of Weems, Shemp, Haynes, and Moore. So we're located at Ellerby Road, 9105 Ellerby Road. Used to be at 912 Kings Highway, right there close to Byrd and St. Mark's. So there for many, many years, and now relocated out on Ellerby. So we've been there 2 years. As I mentioned, Vicki Reck is in the back of the room there. She works with me. I always tell people she's too smart to be a lawyer, so she is, we call her client care coordinator, but a big part of my practice is to help families navigate from getting some type of diagnosis or have some type of physical impairment where they can no longer stay at home and are looking for transitioning into long-term care, and how to pay for those, what benefits are available. And so Vicki is essential in that area with that long-term care planning, certified Medicaid planner. And so in the estate planning world, or also I get labeled as an elder lawyer, even though my early gray hair, I'm only 52, and so, but the practice of elder law has developed over the years, and it has to deal with planning for people who are, again, structuring their assets, trying to deal with how to pay for the long-term care and planning ahead. So anywhere from what we're going to talk about today is essential estate planning, what I call estate planning 101, basic wills, power of attorneys, living wills, kind of the big three documents that always say that are just baseline that everybody should have as they are at any time, but most important as you are getting to a point where aging and looking at needing somebody to maybe step in at this point or in the near future to help assist with your medical decision making, financial, and anywhere in between that. So we have some handouts here that not sure that did everybody get one at the table? Pass those around. Yeah.
The other stuff is just extra,
Yeah.
little line
So-
up for the road.
Did I give everybody? Thank you for a lovely assistant
I
there.
already have it.
Okay.
That I can do.
Yes, thank you. So, so generally what I talk to everybody about is, again, the big three documents. Will, when you pass away, how do you want your assets to be inherited and by whom? Generally, you need to appoint somebody in the will as the executor, is what we call them, and to make sure your wishes are followed through with. So get in contact with the lawyer, make sure the will is presented, and whatever assets you have at the time, get into the hands of your heirs as you've indicated in there. So that, again, is what all people, is whether you have a lot or little, it's irrelevant, is that a will is your intentional instructions of how you want your assets inherited. I tell everybody that Louisiana law, if you do not have a will, Louisiana law provides a will for you. It's written right into our laws. It's called our civil code, or people call it our Napoleonic code. But so if you do not have a will, our Louisiana law will tell you how your assets will be inherited. Probably the biggest question I get about wills is that, and inheritance, is that spouses do not inherit from each other by law in Louisiana automatically. Meaning we come from our European, the Napoleonic, French, Spanish, where heirship goes through the bloodline. It goes down. So your assets go down to your children primarily. And so spouses have rights of use, and there are certain provisions for the spouse over those assets. But at your death, if you're married and the first of you to pass, the spouse by law does not inherit everything that y'all have together. And we are what we call a community property state, meaning that while you're married, everything that you acquire, buy, purchase, earn during the marriage is presumed to be 50-50. You have 50% ownership, your spouse has 50% ownership of those assets. If you come into the marriage with property, or you inherit, or somebody gives that property to you directly while you're married, that separate property, that 100% is yours, and 100% will go to your children by law, unless you have a will otherwise. So, it is very important, that in those situations where this may not be your kids together, you may have stepchildren, you may have children that are estranged from you, you may have that are not good with money, or may not be on the same page with you as the surviving parent, to protect yourself as either one of you with a goodwill that says, and be clear, what assets are going to be yours, what assets would be the kids, if any.
I have a question.
She has a question.
My brother.
I like questions.
My brother lives in Texas, and we were talking not too long ago, and he asked me if we had, if I was aware of something called death transfer.
Okay, so.
I don't know what that is.
Good question. So what the question was has a relative in Texas, and that was asking about, do we have transfer on death, or what you may be called a pay on death account, okay? So Louisiana law does allow you to name a beneficiary of certain types of bank accounts, CDs. You can sign paperwork at the bank that says, I'm the owner now, at my death, I want to pay this account to this beneficiary. That pay on death or transfer on death is allowed in certain limited situations in Louisiana. The idea being that we do want and do encourage easy, non-contested transfers of assets to heirs to happen without having to go to court to petition, tie up litigation, and have clog our courts, when a very simple transaction, nobody's contesting it, it's very clear who the beneficiaries are. We do encourage and have allowed those transfer on death designations. I can tell you that with everything that Louisiana law, the banks and the financial institutions that are there to their forms and how they fill those out, they're bank workers, okay? And they follow their form books. They may not know the law, and so I have seen, even though you have designated it on their bank form, it may not comply with the law of that. And you would think, well, the bank should know that what the law is, but I can tell you that some of these banks that have multi-state jurisdictions and operate, they may not have completely adapted their forms and the law, because the banks have a big lobby in Louisiana. The law says that if the bank messes it up, then you can't hold them really accountable. So buyer beware that it always, any of those accounts, I still encourage people, belt and suspenders, even if you have that designation on some type of bank account CD, okay? Make sure your will, a good will is there too to back that up, and make sure you have it and get good advice on how to do that. And don't take legal advice from a banker, because again, you don't know how long they've worked there, who they're talking to. And so again, it's worth time and energy to go and get some good advice. Make sure that those coordinate and you're on solid ground with those forms.
So I need to go to the bank, and I need to say that, make sure that I have beneficiaries on all my accounts.
Well, you can't, I mean, that is a place to start. Yeah, so that, I mean, that is again, is that may be available. Again, in my experience and advice to you would be, don't rely on that just solely. Okay. So that again, that it would be something that you could coordinate and make sure that happens. Now we have Certain assets, like retirement accounts, are very, because everybody now has participated at some point in putting money into a 401k, then that becomes maybe an IRA, or you've then invested in an IRA during your work life, and now that you have that asset, and a lot of people now save money in their IRAs and these retirement accounts, okay? That asset, those retirement accounts are by law, have to have a beneficiary designation on it, okay? Anybody who sponsors a retirement account, as part of that, they are supposed to make sure that you have at least a primary beneficiary on that account. Now, if something happens to your beneficiary, say your beneficiary predeceases you, then that paperwork will have contingencies built into it. If your primary beneficiary predeceases you, then we will pay. Do you have a contingent? If no contingent, then they will go to usually their spouse, children, some family hierarchy in there, and ultimately your estate. So if they can't find a person, then they would look to whoever would inherit your other assets by law, and then that ultimately would be the heirs of that account.
Just, I'm trying to follow the logic.
Yep.
I do have a will.
Mhm.
My wife has Alzheimer's, and I'm the caregiver. And we have historically done everything jointly. CDs, that kind of stuff are all jointly owned by us. All the accounts. We have 2 daughters, and they are what I would call secondary, to either one of us. If she predeceases me, does the will that she has a will, I have a will, does that prevail then and become the principal document for all investment accounts, CDs, whatever that might be? Does that have, it's the timing I guess I'm driving at. Does that like kick in automatically? Do you just show that to the Edward Jones or to the credit union or wherever, and or the bank, and then they can accept that and will be guided by what the will says? Or do you go through, I've heard the probate and all of that.
Yeah.
Do you have to go through that process, and how time consuming is all of that? That's really, I guess, what I'm leading up
Sure.
to.
So
too many words.
So in a situation, the question basically is what happens in the real world, right? So when you're married, you've got wills for each other, and you've got children as your backup or contingency heirs. And what happens when your spouse passes? What happens logistically and legally? So the short answer is yes, that when your spouse passes away, the will then becomes the document that is going to eventually determine the ownership of their assets and that are part of their estate. And again, whether that asset is a 50% community property ownership, is that a separate property? Is that a brokerage account that you have a joint ownership with? Is that a tract of land, a 40-acre tract of land that you may have co-owned with a brother? So any of that, that's part of what the executor or the heirs would do, is one, to find the will, determine what assets comprise the estate, and before the will to be deemed legally valid, it does have to be presented to the court for validation, okay? And that process, that legal proceeding, is called probating. You probate a will, you present it and have it validated or declared to be a legal document. We call that in Louisiana, so the overarching term in Louisiana is called a succession. So successions is what we call in our laws the transfer of assets from a decedent to the rightful heirs, whether that's through a will or by law. A succession is the process, the legal proceeding that you would be referring to in Louisiana. You can probate a will. If you have a will in the succession, you're presenting that will to the court. And so other states, common law states, have a actual probate court. All they do is handle family heirship, probating wills and dealing with deceded assets. So we don't have a separate probate court in Louisiana. Our district courts that handle civil matters, they can have criminal matters, and that all of that's a civil proceeding. So you would present that in a petition to the court, say here's the original, then people have to attest to that. I'm the heir or I'm the named executor. I present this will to the court, and the lawyer prepares that petition, that legal paperwork, goes to the judge. Usually those are you don't have to have a formal court hearing for those. It's a pretty straightforward, if you have your documents in a row and there's really nobody contesting anything, you submit your paperwork, it goes to the judge's office, he reviews that, or his law clerk mainly reviews the paperwork and makes sure that it's all in order. And in Louisiana, we actually get a court order. So what you would get from the judge is saying, all right, here's the rightful heirs, and here are the assets that they have presented to the court. So you have to put forth what assets you're asking the court to legally transfer to you. So that's where you were coming in, is that if you just took your will out of the envelope the lawyer gave you, and you took that to Edward Jones says, I see the will, but you need to go have it submitted to the court. I need an order. I need to have some legal document that says this is a real valid legal will.
How long does that process take from the time it's presented to the judge, clerk, whatever, and the order being issued? Is that a lengthy process or rather straightforward, or what?
So the question is about the time. How long and how does that process take? I say this to a lot of people, clients that I meet, is that succession or probate in Louisiana is very user friendly. As much as we get cracks on our laws and how different we are, the succession process of transferring assets in a non-contested family situation, you could be in and out in 30 to 60 days. So generally, by the time that you have gotten through the services, you've gotten your kind of ducks in a row, go meet with the lawyer, present the paperwork, you get the signatures from all of the heirs or whoever that may be involved. Once it goes to the court, it gets back to us in probably about 2 weeks. So we are not a creditor publication state that you may hear about. Probate in other states could take 6 to 8 months, maybe a year time, that you have to, some states require executors to present wills and they have to publish the death out. So anybody who may have a claim against the estate shows up, presents their claim, and then the executor can settle those and deal with them during the course of administration. Here, we put the onus on the creditor that if the heirs understand what they're receiving, their inheritance, and they're willing to take any debts that come with that we leave that to the heirs to make that decision. That if they say that you had some outstanding credit card bills, or you had a hospital bill for a couple $1,000, and you knew about those as the spouse and heir. If you were willing to file the will and take ownership of the assets, the judge would then allow you to have ownership of the accounts, and then you would pay the bills out of the money, and however you choose to do that, it would be your choice. So in a situation like that, we don't, we move forward pretty quickly when we understand what we're dealing with. Now, sometimes, there's debts that outweigh the assets, and those are a different animal. But traditionally, like what you're talking about, is family been married, 30, 40 years, 2 kids with each other. You have wills that say, I'll leave everything to my spouse. That's you're talking about maybe 30 days, 45 days.
64 years.
64, wow.
Whoa.
Wow, congratulations, that's unbelievable. People don't stay 64 weeks anymore, and it's running 64 years, so that's awesome. So again, I deal with a lot is the real world and the legal world and how to navigate that, and that's where having somebody to help make that navigation for you, yeah, most of the time, would it make a big difference in how the inheritance would operate in a family that's like that? Probably not. But again, having that to navigate that process and help you, that's where good legal advice, having somebody available to you can help save you a lot of these headaches, because like I said, bank law, financial institution law, they make their own rules because they got the money, so what I tell people, what they tell you is what they're told. I'm only gonna tell you what the law is, and so we have to make those navigate. And a lot of that is people think joint ownership of accounts, I have a commingled bank account that either or should anybody who gets the money, my name's on the account, I should be able to get all of the money. I've seen everything, that they freeze the account, they may not have any right to, but somebody there at the bank level says, oh, we have a deceased account holder. We need to stop any of the spending because we don't know, are there kids or stepkids, is there will? But again, you have, that's just real world. I mean, people, it's not always perfect. Now again, 95% of the time, never a problem. Spouse accounts, you could operate that way for years and never have to go through. I mean, people wait for probate. If you live in the house that you own, you have bank accounts that you own, the names on the car you drive, you may never see a difference in that. It's only when you have to make a change, if you want to remove a name off a bank account, you want to transfer a title to a vehicle, you want to go sell that house, then that's when the real world asks you, where's your ownership for your deceased spouse? What happened to their ownership? And that's where that probate paperwork comes into play is, here, I'm the sole heir, I now own 100%. And that document is your proof to the world, now I have this, I am the sole heir. And so that document is what you would present to Edward Jones and to the bank, that you would go in and say, here's my court order, I've been declared the rightful heir, and now this asset belongs to me, do this with it. Just remove the name, put it in a new account, give me my check, whatever you decide is yours at that point legally. And so they will take direction from you from at that point. So, but like I said, in that most situations, people do defer, and there's, you may wait a year, just 2 years. Like I said, it's really, there's not you have to go forth. If you're the ultimate owner of it, that process can occur on your time frame. So people ask, Kyle, what should I do? Should I call you? I said, absolutely call me, but there should be no urgency to it. If you've gotten your planning in a row and you have access to funds to take care of you, you're still paying your bills, you have no complications, then we have time. There's no rush to get that done. Then we can just operate on a time frame that's whatever's convenient for you guys. So, but it's, like I said, it's good to know those things, have that plan of action. And especially what I tell the Wills is that your backup person. We always, if the spouse is there to handle it, where, everything about the finances, how to, where the bank accounts are. But if something happens, spouse passes, and then you are either hospitalized or lacking capacity, who's that backup person that you're going to look to help you when that time comes to navigate those financial decisions and make sure that things are taken care of? And so I always preach and encourage to have one backup at least. And I said multiple kids, that's, family dynamics, friends, somebody that you can name as a backup, as a contingent, and then put them on notice that you've asked of them, if something happens, would you be willing to? And then at least they will have notice, because some people put, oh, well, I'm gonna ask my cousin and I'll just put them in the will now. I said, well, you need to make sure that they know what they're getting themselves into. Oh, they'll be fine. And have the conversation, well, did they tell you you were gonna be the executor? I said, no, I had no idea. The kids called me and said I was named an executor. She never said anything to me about it. So again, you want to make the process is difficult enough when you've lost a loved one. Then if you don't have organization and have things in a row, it just further complicates the matters and makes it more stressful on the people left behind. So getting those things taken care of, having it laid out in a very simple, either 3-ring binder, folder, here's where the accounts are, here's my contact people, I got a lawyer, I got the CPA, here's where my financial advisor, your team of people, whoever you look to handle those affairs for you, just have them a little cheat sheet for the heirs behind and the executor, so that they can go to the people that you've trusted and helped you along the way. They can start there, and then that way they don't need to know the great details about what's the value of the account or how much life insurance you have. If that's not the important thing. It's, are they willing to help? I've got a plan, I've got it all laid out, and I just need somebody to go execute on it.
I got a question.
Yes, sir.
My wife had Alzheimer's also, but 2010, we both had wills made up. And at the time, of course, if I die, everything goes to her. If she dies, everything goes to me. Contingency was our son, our only son. He's estranged from us now and has been for several years. And just recently, of course, we raised his 2 autistic grandsons. Just recently, they went to Holy Angels, and I decided to have the wills, redone. I took my son out of my will because I know that he was in it, he'd squander everything and would not take care of his mother. Put everything into a trust for the autistic grandsons. When I went to try to change her will, the attorney told me we could not do it because she has to approve it, and she has Alzheimer's and she can't do that. Even though I have a power of attorney, he says you can't do it.
That's what I was gonna ask about, powers of attorney.
Okay.
Does that supersede?
So the question is, what powers do you as a power of attorney have to change the estate planning or make changes to the estate planning once a loved one or family member has, becomes incapacitated or lose their capacity to make their legal documents? So the power of attorney is a appointment of your agent to handle certain matters, whether that's financial, medical, or both, in a legal document that you've appointed an agent, and primarily always the first option available is the spouse. So we have that there. What's in the power of attorney and what powers you have, is the devil's in the details. So if it is what we call a general durable power of attorney, general in nature meaning that it covers both financial and medical decision making. So we do some. You may have a separate medical power of attorney that and has your appointment of these people, and then you have a financial separate. Sometimes we put them together if they're the same. If your power of attorney is the same person, and then we generally can just put that in one document. But sometimes, for whatever reason, just logistics, one child or maybe a backup to handle medical, one child or somebody may be more suited to be financial. So you can have all of that in between, but generally the buzzwords, what you see is general power of attorney, meaning, like I said, both can financial and medical. Durable, the durability means that it's meant to last when the principal becomes incapacitated. so that some power of attorneys, mainly in the business world, that if I have appointed somebody to go do a business deal on my behalf, and then I become incapacitated, I may want that power of attorney to cease if I become incapacitated. So the family planning power of attorneys, that's when we need them the most, is when the person becomes incapacitated. Then I have a right to act. So when you see durable, means that it's a legal term that means that it's meant to last all the way through incapacity until death. The other key note about power of attorneys is that they do stop to be effective at death. A power of attorney can only represent a living person, okay? Then at death, your estate's created, and then an estate representative, either executor or a court-appointed administrator, then assumes that responsibility of assets and being able to deal with the assets. But the power of attorney, by its term, most standard way of doing it is that you sign it, it becomes, you make your appointment, it's effective, and that it will last unless you revoke it. You always have the right to revoke your power of attorney, but otherwise it'll cease upon death. Now, in that power of attorney, it may have allowed you to sell the spouse's assets. You may have a right to set up trust for the spouse. You may have a right to do certain transfers. But you cannot write a will for a spouse or anybody you're serving as power of attorney. It has to be personal to you. You have to have capacity to do that. It's very limited in that nature. And we don't do joint wills in Louisiana, meaning you have your will for your assets, your spouse has their will for their assets, and they meant to work together. But and what we face that a lot is that what happens when things change, the family dynamic changes during the course of the dementia, and now we may be stuck with something that we didn't intend 10 years ago. It presents a very difficult problem in the estate planning world, and so either, that is where we can maybe use trust, or we may be able to legally use the power of attorney to do some planning that changes that. But it is a real problem, and what we're told is true, is that you cannot undo her wishes at this stage. Now again, we have proceedings like an interdiction, or what we call an interdiction proceeding, and a guardianship proceeding, that is the terminology to have given authority. Sometimes that the power of attorney may not be as clear as we want it to be. It may not cover all of the powers that we need to do at a certain time, and sometimes we do have to go get court permission to do certain things on behalf of the principal, the spouse, if things change to a degree and it can hurt them financially, or that it just doesn't make financial sense for them. Sometimes we do have to go get court permission to do those things. So always the focus is it in their best interest? Is it in, it's often hard in the family world is to separate our own wishes and our own feelings and what we believe our spouse would want versus what, what would they say here, what would really be their wishes. And it is very hard for mothers and generally, because of the fact that they generally don't want to feel like they left their kid out, or remove a child, equate inheritance with love. And so I always joke on my mom was that doing their planning, they always want all of them to be treated equal. I don't want them to think, well, I love one of them more than the other. And but to your point is that's why it's important to get on the front end as much of that and have that worked out and give each other flexibility to do that if the family dynamic makes sense. I can tell you if you second marriages and you have stepchildren involved and dealing with my mom's assets and my dad's assets, it can cause a very contentious situation. And so if, again, have that in your family, getting ahead of that and making sure that you get advice on the front end is always the best, way to do that.
So are you saying that, I could go through getting an interdiction on her? And would I be able to change it then?
Like I said, it all would depends on the changes, but again, it would look to what the power of attorney allows you to do or what you would, be able to do that with. Because sometimes, like I said, there's maybe powers of assets to you as the spouse, and, so there are certain things to look at that, whether or not through the power of attorney or asking court permission to set up some type of trust, those are always available options to do that.
Yeah, see, my concern is, I mean, if she passes before me, there's no problem.
That's right.
But if I were passed before her, then she can't take care of herself, then it's probably all gonna go to the son. And I know for a fact that he's not gonna take care of her.
Yeah.
And I guess I would have to prove that to the court to.
Yeah, I mean, that would be to allow you, either you to take ownership of the assets that y'all have together and deal with them as through your estate and have that planning through yours to protect her. And that's generally the underlying theory, is that you're trying to help prepare in case you predecease her.
Right.
Do we have protections for her? Now, again, ultimately, who inherits that or how that shakes out, that's a more difficult issue. But planning ahead to make sure in case something happens to you first, and that's always essential and needs to be considered when you have somebody that lacks the capacity to make those financial reasonable decisions for themselves. That is always a big concern in our world, because like I said, you can be dealing with this disease for years.
Right.
And the dynamics of all of that and life happening to you in real time is, you need some flexibility, but sometimes there's just, life puts us in a spot. So, but that is all, like I said, it's all good questions and they're not real good answers. It's just, it all kinda depends, and we do the best we can, yeah.
Deal with a personal situation here, much like what he was addressing here. Mine's not quite as complicated as his. My wife still can take care of herself, even though she has the beginnings of Alzheimer's. She does fairly well. You know, she can do crossword puzzles better than I can. And I've got an MBA. But our wills are somewhat dated. You may remember Sid Nelson.
Oh, yeah.
Okay, Sid was one of our best friends, Sid and Gail.
Yeah.
But, he's of course since passed away, and as has Gail. But they do need to be updated, because our daughters were young when Sid did them for us. So that's a bit too personal, I guess, but anyway, what I'd like to do is get the wills updated. I'd like to have our two daughters present because, they're there. Now, they have children, we have grandchildren, not a lot, but some. But I'd like to have those reviewed. And, is that the kind of thing that your company does? Could all four of us come and meet with you or whoever, somebody in your office, whoever does this kind of thing?
Absolutely.
And bring the wills and say, and if you think so, a list of our assets and so forth, you say, now this is what we think we want, and then Frances, she can agree or disagree, but more than likely she'll agree, you know.
Sure.
Because we're pretty much in tune with all this together.
Yeah. So the two main points, and I think is great to point out, is reviewing your wills and how often to do that, or when does that need to happen. And wills are valid when you sign them until you pass away or you revoke them. Okay. So, but like you just explained, you may have a will that has provisions for when you had young children, you were getting started in careers, you may have a lot more debt than you had assets. and your life looks a lot of different 40 years down the road. So I tell people that life events, like I says, as kids become adults, they move on, the things that you may have needed to protect minor children, you no longer need that. People that you had appointed as executors, siblings, other family members to watch after your minor children, they're aging as you have, and you may need to now have your children that are mature, working healthy adults to substitute in for those people, and they can handle those things for you. So they're always flexible and can be amended at any time while you still have capacity to do that. I do think the second point he mentioned is bringing the family in, especially when you're dealing with diagnosis like dementia that is going to be gradually progressing, and having those tough discussions with the children or the people that you're going to look to help in that transition, and to make sure you're on the same page and everybody hears it from you about what you want and how you want to be treated and where you want to live, and the resources that you have set aside, and the plan and developing that, so that as it goes through the process, that everybody knows their role and what your wishes are, and then can follow through with that the best that life will allow us to do. Now, always things will throw wrenches in them, but I think it is a great point to sit down and have that discussion and let the children, because they also have questions most of the time. They don't know how to step into helping you. They don't want to be over pushy sometimes. They're scared to ask questions about finances, and sometimes parents are very tight-lipped about their finances, or keep their personal information close to the vest and don't share that with their family. They're not a sharing type family. But when you start down the road of looking to and may need them, you want them to be on the same page with you, understand what you're asking of them, and that having that discussion while you still have capacity to do that and explain those things is always beneficial in this race. So I do agree with you, and it is a good way, if that your family dynamic allows that, to have that kind of transition talk, looking for the future, making sure everything's in place, so that when the tough times get there, they know what to do and they have the tools to help you. Because that's really what the documentation is to do, is we need it to sit in a drawer until we need it. It may never. It may just, live to be 105 and pass away gently into the night one night, and never needed a power of attorney, never need to see the light of day. All things were good. But you have them in the rough time, and to have that's why they're there. And it's all families are different, and that's why they need to be specialized and specific to your needs. And again, that's all that matters, because there's a lot, I heard this case where this family, or my friend did this, or my friend told me that this. I was like, well, they may have told you about 80% of the story. What's really important was the other 20%, So I think the good two takeaways, again, is review them, dust them off, find them and look at them and see what did they really say. And then two is, if they need to be refreshed or just discussed, call the family meeting, sit down, have to go through those, because inevitably there's always some legalese in there. There's some terminology, or again, if you get a long-winded lawyer that puts a bunch, you go on pages and pages of stuff and do not understand it, or I hadn't looked at this in 30 years. So all of that, bringing that back out, looking at it, does it still match what your intent is? And then if changes need to be made, then we can look at how do we get that change. And a trust is being common. I get asked about that a lot, especially with the New Year's and the advertisement from the online, log in and get your trust for $99 or whatever that is. So And trust are just a different tool. So again, everybody starts wills, power of attorneys, living wills, and then trusts are just another a tool that we use in specific situations to deal with that. And so, again, that trust used to be thought of as the Rockefellers and the Vanderbilts and the Kennedys and the Trumps of the world, that you have monies and all over that needed to pass great wealth, but it really has become a tool that we use for just everyday middle class planning when we have situations where we need to utilize that in the long-term care world. So I'm always keep it simple first, and then add the layers to it as the complexity in the family happens. But again, that's things that just need to be tailor-made to the situation. And again, I'll touch on the living will, or what we call an advance directive. Not sure how we came about the living will versus your will. And it's like, why is I got a dead will and a living will, or why do they call them that? And so, a living will, again, is a specific document that deals with end-of-life decision-making, okay? So it's an instruction letter to your medical power of attorney to how you want to be treated in that situation where the doctors have examined you and determined you to be terminal and irreversible. It's not like the Lifetime movie Coma, where you wake up after 40 years with a beard and you still have all this brain activity and you walk out that's not what we talk about. And the other thing it is not a DNR. An advance directive is not a do not resuscitate.
That's a separate thing.
It is a completely separate animal, meaning if you have a living will and you had a stroke at home, you absolutely want people to call 911. You want EMS to show up. You want them to get you to the hospital. You want them to stabilize you, and then figure out what's the next step. When you cross the line into a DNR after a consultation with your primary care physician, and that election, if you decided for yourself with the doctor's advice and order, that at that point you're not taking any further steps to life-sustaining measures, that if something happens thereafter, I'm good, let me go, okay? So two completely different documents, and the one that we always start with is the advance directive, the living will, because it is a personal choice for many, that it is a very difficult choice to put on somebody else, like a child, or if you don't have, whoever your medical power of attorney may be, a friend, a relative, but again, it's your body, it's your wishes, and that's all that matters. And so the primary election is that, do you want to have IVs and feeding tubes to sustain you? They're not curing you. They're not gonna get you well and get you out, but they can sustain you, okay? So life-sustaining measures, when you become unable to eat and drink on your own, would you want these measures to be taken? So that decision is really what that living will and advance directive is aimed at, to try to make your personal decision known, so that if the doctors consult with your medical power of attorney, they're gonna look to them, what do you want me to do? And they will take the advice and instruction from your power of attorney. The living will is to guide them if they're faced with that decision. Well, this is what they chose. Said, if you're telling me and this is the diagnosis and two doctors have confirmed it, then if you've said, I do not want to just be kept alive just for the sake of being kept alive, then the medical power of attorney can present that living will and says, this is their choice, implement it, okay? So that's a tough thing to think about, because inevitably we always get questioned of, well, is the doctor really right? Or am I really terminal? Or am I just kind of terminal? Or what's that, so that's why the power of attorney, the person that you're going to appoint and who you expect to be making those decisions for you, they know you. and they have some, or have had a discussion about that to make good decisions on your behalf, and you trust them, okay? Because that's the person who's going to be your advocate and or decision maker to present it. You know, we always get asked every time you go to get admitted somewhere or have a procedure, do you have a power of attorney, do you have a living will? Check, yes, I got them. Now again, I don't bring them to every hospital visit, and I don't cloud my medical record with it, but I know that my medical power of attorney knows where they are and how to get a hold of them in case I do need them, and had that discussion. So I think that back to good communication, who your people are, and again, I know life's not perfect, and sometimes we just don't have those people, and it happens. There's a lot that have outlived their support group, you know, and so we see those clients a lot too, and you know, again, it's just part of life, and we have ways to deal with it. But again, that's why having your situations and everybody's family is just, that's why it's important to you, and that's what we try to accomplish, is getting things that help you in your situation and may not be just what everybody else gets. So between those three, like I said, I think that covers you from now till in life, and then those three documents are pretty much the baseline of all, you know, the estate planning. You know, once of that, I think you've covered your bases. You've done almost everything you can do, and then from there, like I said, you just kind of make some tweaks and add-ons to that. But I think if you start there, you've done a great service to your kids, your heirs, and it would be a blessing to them for sure. All right, guys, that's my time, so I think we're going to time off, but I'll be here for a second. And I have some cards and other handouts up here for you as well.